Good afternoon, everyone. You'll see on the screen here, I've been an attorney with Tully Rinckey practicing in this field somewhere around 5 years, working with multiple different agencies to include those listed there on the screen. I've worked with each and every one of the guidelines that you'll find under the Security Executive Agent Directive 4, which is the executive agent that the agencies use to adjudicate security clearances. In that, there's 13 guidelines that they have both disqualifying conditions and mitigating conditions that are considered when determining whether or not it's clearly consistent with national interest for someone to hold a security clearance. So today we're going to be talking about Guideline J. So just as a disclaimer, this is not intended to be legal advice. The views expressed in this publication are my views and do not imply endorsement by the Office of the Director of National Intelligence, the intelligence community, or any other government agency. It's for educational purposes only. Okay, we can move on. So today, again, we're talking about Guideline J, criminal conduct. The primary concern with criminal conduct is that criminal activity, as you see here, creates doubt about a person's judgment, reliability, and trustworthiness. By its very nature, it calls into question a person's ability or willingness to comply with laws, rules, and regulations. The executive agent expands on this in Section 31 that speaks to 5 disqualifying conditions. So when they're reviewing a past or an individual for past criminal conduct, they're looking for a pattern of even minor offenses. Any one on its own would be unlikely to affect national security. A good example of this disqualifying condition is a pattern of traffic offenses. Traffic offenses that result in a charge over $300 or a court summons are required to be reported on the SF-85 and SF-86. A pattern of those minor offenses, for example, could be something under 31A. That would be found to be a pattern of minor offenses that could be a disqualifying condition. Another disqualifying condition is evidence of criminal conduct, whether or not you were charged, prosecuted, or convicted. So this we'll talk about a little bit later in discussing reporting criminal activity, but it comes up in disqualifying conditions can include even an arrest, even if there was no charge, the charge was reduced to a lesser charge, or it was ultimately dismissed. The underlying arrest and reason for arrest can be considered as a disqualifying condition. Under 31C, disqualifying condition can be whether or not an individual is currently on parole or probation. Even if that person is complying with the terms of their parole and probation, the simple fact of being placed on it in the first place can be disqualifying. A violation, of course, or revocation of parole or probation for a violation or failure to complete any court-mandated rehabilitation program can also be a disqualifying condition. That could be a Mothers Against Drunk Driving course, a pretrial intervention course, anger management courses, DUI courses, all of those. If there's a failure to comply with any court-mandated rehabilitation program, that can absolutely lead to disqualifying conditions. Lastly, for the disqualifying conditions, you have a discharge or dismissal from the armed forces for reasons less than honorable. And of course, they would take into consideration what those reasons are to determine whether or not it's ultimately disqualifying. Now, with every disqualifying condition under the guidelines, there are several mitigating conditions which can be applied to the case and reviewed to ultimately overcome the disqualifying condition. So a few of those under Guideline J, there are 4 of them. When they are reviewing someone's past criminal conduct to review whether or not they should have a clearance, they look at how much time has occurred since, or elapsed rather, since the criminal behavior. There's no bright line rule to say that a specific amount of time since the criminal incident occurred is an absolute mitigating condition. So, there's nowhere in the rule book that says it's been a year since my criminal incident, I'm going to get my clearance. Absolutely. The timeline can be all over the place because so many different factors go into whether or not someone is eligible for a security clearance. They also look at the circumstances that the criminal act occurred under, if there were unusual circumstances, if it was out of character for that individual. But ultimately, in mitigating condition A, they're looking for confirmation that whatever activity occurred, it's unlikely to recur again in the future. The second mitigating condition that they apply in this case is they look at whether or not an individual was pressured or coerced into committing the act, and whether or not those pressures are no longer present in a person's life. So that could be, let's say, drug use, for example. And we'll talk more extensively on how drug use relates to Guideline J and criminal conduct later in the presentation. But with this, they look at whether or not maybe friends or close family or someone you were connected to pressured you into committing the criminal act. Mitigating factor C is no reliable evidence to support that the individual committed the offense. Part of that can be argued, if there is an arrest, but there was no evidence to support a charge or a conviction, that can be applied in that category. It can also be argued if the information that resulted in the criminal conduct came from an unreliable source. I tend to argue, if there's a domestic violence and there's argument over, dispute of fact of what happened, there's argument to be made regarding where that evidence came from. If it's testimony that's changed, if it's unsupported by documented evidence, those are arguments to be made in that section there. As far as the last mitigating condition, the government's looking at whether or not there's been successful rehabilitation. So they're looking at, yes, this criminal incident occurred, but what's occurred since then? So they take into consideration, again, the time without recurrence of new criminal activity, whether or not you complied with court terms like paying restitution, completing parole, completing any of the court mandated courses, whether or not you've gained job training or higher education, whether you've maintained a good employment record, or constructive community involvement. So that could be community service and other ways that you've voluntarily engaged in positive community service and advancement in that category. So our next slide here is the importance of accurate reporting. This somewhat ties into a previous webinar I've done on Guideline E. A lot of issues come up with criminal history when you're initially reporting on the SF-86 in the way that the questions are written on the form. A lot of individuals have potentially received information from their criminal attorney, maybe recently or several years ago, that a charge was dismissed, adjudicated no prosequi or no pros, dropped to a lesser charge, or it's been expunged or sealed from your record. Former attorneys, criminal attorneys, may advise that you don't have to report that on your work applications and other applications moving forward. However, the one exception to that rule, and there may be others, but one vast exception to that rule is your security clearance application. Regardless whether an arrest, charge, or conviction was sealed, expunged, dismissed, it still needs to be reported, and the outcome of that charge needs to be discussed within the criminal history section. It's very important that you include and properly respond to all the ones that fall within the specific time frame questions that ask in the last 7 years, has such and such happened, and also the have you ever questions. Part of the background investigation involves searching criminal court records, FBI systems, the other items that they have access to, which usually elicit all of these past charges, regardless of whether or not they were sealed or expunged. So the failure to report, even if it's a mistake, can be very difficult to overcome, because the first assertion and thought of the government is that you're trying to hide this charge and hoping that we won't find it because it's been expunged or sealed, when likely it was just a mistake or error on your part, or receipt of poor guidance from past counsel that doesn't work in the security clearance environment. So it's very important to properly report. Additionally, we recommend providing additional context as much as possible in that explanation to not only properly report the criminal activity, but also to provide as much mitigation as you can. So I want to talk about Guideline H and how that ties into Guideline J. There's been a lot of recent confusion with marijuana use and its legalization in several states for medicinal and recreational purchase. It's important to note that because it is still federally illegal, that when there are reports or they find out that there has been illegal drug use through the background investigation, they will bring a concern under both Guideline J and Guideline H. Guideline H, of course, for the use of illegal substances itself, THC still included in that, and also Guideline J, because the purchase, possession, and the use of it is still federally illegal. So you have to overcome both areas typically when you report past drug use and or you have a clearance, and then you have to self-report because you used while you held a clearance. So it's very important to mitigate on the SF-86, and if you have to self-report use after the fact of gaining a clearance, from both aspects, the Guideline J perspective and also the Guideline E, lack of candor and personal conduct. Guideline H and Guideline J. And you want to make sure it's accurately reported, because if that fails to be reported either on the SF-86 or during the interview, it can also bring the Guideline E, which is lack of candor. So all of those three put together in combination can be very difficult to overcome if they were to send out a notice of intent to deny your clearance or notice of intent to revoke if you already have a clearance and have to, bring these issues up at a later point. Something that's very helpful to get ahead of, this kind of time more in the Guideline E, but self-reporting and reporting in general from the very beginning is highly recommended for each and every guideline. If it were to ever come up or be found out without you reporting it initially, it's much more difficult to get over and to mitigate in that respect. So keeping all of these things in mind, I'll open up the floor for questions. I think that brings me to the end of my PowerPoint, I believe, Taylor. Thank you.